Hi everyone, thank you very much for joining us today. My name's Kaylee. I'm the director here at NB Property Law, and today we're going to be speaking about the new residential contract and the seller disclosure statements that are now required for all properties being sold in Queensland from the 1st of August 2025. So a little bit about us here at NB Property Law. So we are a legal firm based in Brisbane, Milton. We offer a personalised, proactive advice to our clients to help them minimise the risk and take the stress out of their next property transaction or estate planning matter. We're more than just a team of legal experts. We're dedicated problem solvers committed to creating personalised solutions to guide our clients forward. We do everything from residential to commercial property law concerns, and we're here to provide our clients with the clarity and guidance they need. So in regards to the new seller disclosure statement requirements that, as I mentioned, come into effect from 1st of August 2025. So we're going to talk about exactly what is that. So it is essentially a statement that's going to be provided by the seller selling any residential property in Queensland to disclose the important legal information and any other information about the property. The seller disclosure statement is going to basically collate a lot of information that's already required to be disclosed, and in theory make it easier for the seller to ensure that they're complying with their warranties, and make it easier also for the buyer to actually understand. So who's responsible then for preparing this seller disclosure statement? So this responsibility falls on the seller or their agent. Otherwise, they can instruct their solicitor to draft the seller disclosure statement, but it is actually based on information that must be provided by the seller or from searches that the seller must provide or give or express authority to their agent or solicitor to obtain. When is the seller disclosure statement required to be provided? So it needs to be provided to any buyer before they sign a contract. So for an auction, this means before the auction actually begins. So anyone that's actually registered to bid must be able to view this seller disclosure statement either physically in paper form or online via a link on the same platform which they will be using to bid on. Now, the seller disclosure statement. So it's not going to disclose everything. There are things that won't be needing to be disclosed. I'm going to go through a few of them now. This is not an exhaustive list, though. It's just a few of them that we will mention. So if the lot is a proposed lot, so that's, a property that's being purchased generally off the plan. So with off the plan properties, they have their own disclosure statements that are required, which are far more extensive than these new seller disclosure statements that is needed to be given. So they're not required to provide this particular seller disclosure statement form. If the sale price is more than $10 million, including GST, the buyer can waive the requirements for a seller disclosure statement to be given. If the parties are related, so all parties must be related, not just, for example, one, if there's two buyers or two sellers, it can't just be one of each, for example. All of them must be related, and they also still have to give a waiver to the seller disclosure statement being given. If the buyer is the actual government or an authorised entity for any resumption of land or acquisition of land, any statutory body or a listed corporation or subsidiary, then they're not required to provide a seller disclosure statement. If the seller is the local government and they're basically taking possession of the property due to overdue rates and charges that the seller or current owner of the property has failed to pay, then they also are not needed to provide a seller disclosure statement. If the seller and buyer are co-owners, no seller disclosure statement will be needed. And if the sale is to give effect to a court order, an enforcement warrant, or a financial agreement. So, for example, in matrimonial property settlements where, one party is taking full ownership of the property and taking the second party off the title, then no seller disclosure statement is needed in those situations as well. So the seller's disclosure statement basically contains 6 different parts to it. So the form is a series of yes or no questions. It is a Queensland government issued form. At the moment, we're obviously only in at version 1 of that form, but as time goes on, changes and updates may be given to that form. So it is important that we're constantly using the up-to-date version and checking the Queensland government website that version being used is the correct one. Now, these yes or no questions throughout the form, and sometimes searches will need to be undertaken if there are, the answer may be yes and it's a prescribed certificate. So part 1 is just the actual seller's details and the actual property description of the property being sold. So part 2, this is the actual title details, so the encumbrances and residential tenancies or any rooming accommodation agreements that exist. So the seller will be required to provide a copy of the title search and the survey plan. So title search and survey plans are prescribed certificates. Now, currently, to give you an idea, our search provider who we use for our searches charges about $41 for a title search and $44 for a survey plan search. Details, and obviously these costs will be borne by the seller as the seller needs to provide this information. Details of any unregistered encumbrances not registered on title that will continue after settlement that are known or reasonably expected to be known to the seller. So unregistered encumbrances could include, for example, leases, any access agreements, or any profit a prendres. Now, details required for the leases will include things such as start and end date, any rent and bond payments that have been paid, and whether there is an option to actually extend the lease. We also need to disclose details of statutory encumbrances, including a copy of the plans if available, and this will include manhole covers or any sewage lines. And then details, lastly, will need to be given about the residential tenancy or rooming accommodation agreements if the property being sold does have those types of agreements in place. Now, part 3 of the seller disclosure statement, this is also all about the actual use of the land and deals with the planning environment situation with the land as well. So the information that will be disclosed in this section of the disclosure statement will be the actual zoning of the property. So what's the actual zone for the property being sold. We'll talk about in this part any notice issued by the government entity relating to transport infrastructure proposal. So it will be if it will be located on the property or alter the dimensions of the property. So proposal is either a resolution or adoption of some official process to establish plans or options that will physically affect the property. Now, has the seller received a notice of intention to resume the property or part of the property? So this will, be from a government body that they've got authority to come in and compulsory acquire that property for certain community reasons. We also need to be disclosing information about whether the property has been recorded on the Environmental Management Register of the Contaminated Land Register. Now, searches or notices, if the answer to this is yes, the searches or notices will be considered prescribed certificates that will need to be given as part of that seller disclosure statement. If there is a tree order or application, this needs to be disclosed. And if the property is affected by the Queensland Heritage Act or included in the World Heritage List, this must also be disclosed. Now, part 4 of the seller disclosure statement is all about the actual building and the structures. So if there is a relevant pool for the property and if a compliance certificate has been issued, this must be given. The pool safety certificate or notice of no pool safety certificate is considered a prescribed certificate as well. So it must be handed over as part of this certificate. If the building has any building work that has been carried out under an owner or builder permit in the last 6 years, this must be disclosed. So the QBCC notice of an owner or builder certificate is again another prescribed certificate, so mandatory to provide this. And if is there any unsatisfied show cause notices or enforcement notices that have been issued? Again, another prescribed certificate. So this must be provided in the disclosure statement. Now, part 5, this relates to rates and services. So we need to be disclosing what is the current rates and water charges for the property. The seller's not provided to actually provide the search or the utility notices to show this information. So often a buyer will undertake rates and water searches as part of the conveyance to, check what rates and water are for the current quarter and do pro rata adjustments based on the period that the seller and buyer own the property. That's not what needs to be given here. It's simply just the information that the seller will have at hand, which is just what they're currently paying for rates and water charges. Now, part 6 of the seller disclosure statement is all about the community title schemes and the Building Units and Group Titles Act scheme. So this only needs to be completed if it's applicable, meaning if the property being sold is part of a community title or strata property. Obviously, if it's just a freehold, freestanding property, then this information or this section is not relevant. So if it is one of these properties, then a copy of the most recent community management statement must be provided for the body corporate, and the body corporate disclosure certificate will still be required. So previously, there was always a disclosure statement given when selling a strata property. That statement still needs to be given, so still needs to be the seller obtaining that body corporate disclosure statement, before the contract is signed and provided to the buyer. Now, that's kind of gone through what is needed to be disclosed and included in this government issued seller disclosure form, but obviously there's certain things that don't actually need to be disclosed. Now, some of these things include whether there has been flooding or any other natural hazard history for the property. That doesn't need to be disclosed. If there has been any previous pest infestation, again, nothing needs to be disclosed regarding this. If the building is structurally sound, not needed. This, it's still up to the buyer. Buyer beware. Buyer should still, be obtaining building and pest inspection reports if there's something they're concerned with or want to check. Whether there is any current or historical use of the property doesn't need to be disclosed in this new seller disclosure statement. Any current or past building approvals is not something that will be disclosed, and the seller also doesn't need to be disclosing whether asbestos is present within the buildings or improvements that are being sold. There's no requirement for sellers to also disclose any details about vegetation clearing, koala habitats, or any other restrictions that may apply. So that's kind of a bit of a brief overview about how the new seller disclosure statement works and what information needs to be included. As I mentioned, all this information needs to be included in the government issued form, which the seller can personally provide, complete, and provide to the buyers, or they can instruct and authorize their selling agent or their solicitor to prepare and draft this form, but still with the authority and with some information will need to be still given over by the seller. Now, given we've got this whole new disclosure statement requirements, the Real Estate Institute of Queensland, who provide most of the contracts in Queensland, there's another ADL form that's currently sometimes used. I'd say we see very few of them, maybe 20% of them. Majority use the REOQ contracts is about 80%. So they've gone ahead and both bodies anyway have issued new contracts, but I'm going to focus on the REOQ one today. So it isn't actually a new version of the contract, but just a whole new contract in general that's been issued. So there are now only 2 forms of contracts. So previously, we had if you were selling a property, residential property, that was part of a body corporate, you would use a separate contract to if you were just selling a property that was freestanding. Now, though, it's just one contract. So the contract for sale and purchase of residential real estate covers both body corporate and freestanding houses. The second contract there as well is the contract for sale and purchase of commercial real estate. So the changes that we're going to discuss today are around the deposit under the contract, the land tax and how that operates under the contract, the extension of settlement dates and how this has changed in the new contract, what the GST provisions amendments that have been made in the new contract, and also I'm going to speak about what the body corporate record search changes that have been made in these new REOQ contracts are. So the first one, as I mentioned, was the deposit. So the due date for deposit. So the current position is that or previously, should I say, before August 1st, was if the deposit was payable on a non-business day, the obligation to pay was previously moved to the next business day. From the 1st of August 2025, this has now changed with the new contract, and the deposit is now payable on the actual date, regardless if it is a non-business day. So all other obligations and conditions will still remain, and they'll still be pushed to the next business day. But for the deposit, if it falls payable on Saturday, Sunday, a public holiday, whatever is considered a non-business day, that is the date it still must be paid by the buyer. It will no longer go to that next business day. In terms of the deposit, the other changes that have been made is in regards to the interest. So previously, under the old contracts, the contract was silent regarding, who's entitled to the tax on the interest. From August 1st, 2025, the contract now clarifies that the seller is presently entitled to the interest, and that if the buyer is entitled to the deposit, then they must refund the seller any tax paid by the seller. That's another big change that we've seen in this new contract version regarding, how interest and who's basically entitled to that interest when the deposit is released. The next big change is in regards to land tax. So under the old contract, land tax was not an outgoing, and therefore it was not adjusted at settlement like things like rates, water, body corporate levies were. However, from 1st of August 2025, if the seller is not exempt from land tax, they can nominate one of the three options. So either there's no adjustment if land tax is required, land tax is to be adjusted on a single holding basis, or the third option is that land tax is to be adjusted on the seller's actual land tax liability. So to provide a couple of examples about how this could work. So the first one, so we're going to assume that it's an individual resident of Australia. So this particular person owns one investment property in their sole name with a land value of $680,000, and there's no exemption for this. So the land tax payable on this would be $1,300. Now the settlement for this particular property was the 25th of July 2025, and the buyer would needed to have paid the seller $1,210.96. Now, the other example is assuming that we're a company or a trustee. So this particular person owns, or company or trustee owns 3 investment properties with a total land value of $1,050,000. So the actual land tax payable will be $4,450. Now, settlement still due 25th of July 2025. The buyer in this situation would be responsible to pay the seller $4,145.20 for the adjustment. Now, the extension of settlement. So the current contract does already contain a list of delay events and automatic extensions if the titles office computers it down, but it has now also been amended to include in the legislation, and it cannot be contracted out of. So it's also been extended to include the following entities. So the Queensland Revenue Office, the Reserve Bank of Australia, the electronic platform that we settle on, so often that's PEXA, and also the financial institution, so any of the banks releasing mortgages or providing new mortgages as well. This definition's been extended to include them and is in legislation, so it cannot be written in the contract as a special condition to actually remove that requirement. Now, for the extension of settlement, an adverse delay on the day of settlement that results in a party to contract being unable to complete settlement. So an adverse event includes an event that causes serious disruption to a community, and this could include cyclone, flooding, fire, storm, a storm tide, or a tornado. It could be a public health emergency, a requirement to comply with lawful direction, an act of terrorism, activity related to war, any civil commotion, public disturbance or riot, and an explosion or sudden impact of an object, including, for example, an object from space. So this is an expanded definition from the current contract position, but it is still similar to the current position in the RARQ contract, but it now means that it will apply regardless of the contract being used. For example, in off the plan contracts as well. So the 5 business day settlement extension still remains, and the settlement can also be delayed if the workplace, if the actual workspace, so the online settlement platform workspace, like I said, we often use PEXA, is unsigned between 3 and 4 p.m. and any party has not re-signed the workspace could be reason for the extension of settlement due to that adverse event. Now, the next one I was going to speak about in regards to changes is to do with if the property is a body corporate. So under the current or the previous contract, the buyer needed to include a special condition regarding an inspection of the body corporate records. So, if the buyer wanted to undertake an body corporate records search, they could do so, and they would need to then draft a special condition into the contract, making the contract subject to that those search results, and allow them the ability to terminate the contract and have any deposit refunded to them if they weren't satisfied with the results of the body corporate records inspection search. From the 1st of August 2025, though, the contract's been amended that there's now a standing condition that allows the buyer to include a body corporate records inspection condition. So like, your finance and your building and pest conditions, this is now a standard condition in the contract that buyers can complete and request if they require the contract to be subject to this body corporate records inspection search. The buyer will also have the opportunity to inspect the body corporate records to ensure that they are not materially prejudiced by any of the circumstances. So a lot of the times, our buyer clients will obtain, want to pay the money to get this comprehensive record search. Sometimes they're around, 450 or to 550 through our search provider, and it provides a lot of information about the body corporate. Sometimes, for example, what has been relevant to a buyer is, we've had situations where there's, not enough money in the sinking fund, and they've got forecast works for things that need to be done to maintain the body corporate property, and they're going to have to strike special levies that each the owner is going to have to pay to build up to that amount needed for the maintenance. We've had other issues where they've had the wrong flooring installed in the property, and therefore they've had complaints and issues with tenants downstairs below them. So there's a lot of different issues that can pop up in those body corporate records inspection search. So often the buyers are obtaining them. So it's now a standard condition in the contract that it can just basically tick a box to allow for that, as opposed to having a draft a special condition every time if a buyer does want to make the contract subject to it. Now, the other change, which is quite a big change that we see in this new contract, is the GST provision. So in the previous contract, it would only reference to the purchase price, either including or excluding GST. However, from 1st of August 2025, the seller is now able to nominate the following without a special condition being included. So they can nominate to actually have the margin scheme apply. They can state that the property is being sold as a going concern, or that the property is farmland. Sorry. And then the last thing that I'm going to speak about as additional extra is that under this new contract, it's now clear that the seller is not required to provide evidence that the smoke alarms actually comply. So under the previous new contract version, if a smoke alarm compliance certificate is not provided or not received by the buyer by settlement, then, and this still applies, then the buyer can automatically get a 0.15% reduction in the purchase price to allow for the buyer to then go and have those smoke alarms compliant post-settlement. The seller must also provide the following documents in this new contract if they're in the seller's possession and they're requested by the incoming buyer at least 7 days before settlement. So that's an entry condition report, obviously if the property is rented, and the most recent routine inspection report that's been undertaken by the property manager if the property is subject to a tenancy agreement, the residential tenancy authority, the Form 2 transfer for the bond money that's held, and also the current tenant's tenancy application can also be requested by the buyer 7 days before settlement, and the seller is required to provide them if they do have these documents. Now, that's a bit of an overview of how these new seller disclosure requirement statements operate, the 6 parts that make up the seller disclosure statement, what is required to be included in the disclosure statement and what is not required to be included in the disclosure statement, and who's actually responsible for providing that disclosure statement. So, it is quite a big change that we've seen with these seller disclosure statements, which brings us in line with the southern states that have always had these requirements. And I've also taken you through and highlighted some of the key changes that have also been made to the new REOQ contract that has come into play from 1st of August 2025. If you do have any further questions though, feel free to scan the QR code and book in a consultation, obligation free, with myself or my colleagues, and we can discuss it a bit further or what your next steps are. But I'm happy to answer any questions that anyone may have now. If you want to take yourself off mute or type them in the chat box, I'll give a couple of minutes to wait for any questions that might come through. All right, there doesn't appear to be any questions. If you do have any questions and you prefer not to ask in the public forum, then by all means, my contact details are here on the screen. Feel free to reach out. I'm happy to answer them for you. I appreciate your time though and joining us today. And hopefully you're able to grab some insightful information regarding the new seller disclosure statement and the amendments to the new REOQ contracts. Thank you very much and enjoy the rest of your day.